you very much. That applause is very weak for what has been such a powerful opening presentation for our first panel. Dr. Joseph Tolorunse will still be with us as he joins us for this panel session. So I'll start by inviting the moderator for our first panel, which looks at the theme of this year's edition, Beyond Compliance, Driving Regulatory Certainty and Investment Confidence in Nigeria's Petroleum Sector. Please put your hands together for Dr. Ayodele Oni, partner, Bloomfield LP. The applause is a bit weak. I know the tea break comes up right after this, but please can we just make it a whole lot warmer? Well done, sir. Good morning. And then joining us on this panel, we have Dr. Joseph Tolorunse, Authority Secretary and Legal Advisor, NMDPRA, who gave us a powerful opening presentation. Albeit weren't as compliant to the time, but I know we're going beyond compliance, and Mr. Moderator, I hope we comply to the time given. It will be put up on the screen to ensure that it doesn't drag. So next on the panel is Ijoma Idika, Head Legal and Regulatory Compliance, Falcon Corporation. A warm round of applause for her. Also joining this panel is the General Counsel at Tetra Core Energy, OKZ Oka Ave. A warm round of applause, please. And our final panelist is none other than the General Counsel, Sahara Energy Group, Tolulope Fadipe. Please put your hands together. So we'll be starting this panel. Please, we can't accommodate more time, so any questions and answers should be factored into the time given. If it's 10 minutes towards the end or 15 minutes, it will be appreciated so we can get questions. And please do remember that right after the third panel session today, we'll have an interactive session where your questions will be answered. But if you do have one concerning this panel, it will be taken within the allotted time. Over to you, Dr. Ayodele Oni.
Good afternoon, everyone. I would have said I'll stand on existing protocol, but I am sitting. I don't know if that's allowed. just joking. Yeah, good afternoon, everyone. Welcome today. I have interesting gentlemen and a lady, and we'll be having a quick conversation. I'll put one or two people on the spot. I'm sure Dr. Tolorunse knows that I'll put him on the spot, and I hope the organizers would invite me next time nonetheless, but I will definitely, because I mean it's either we have honest and frank conversations or we all go home and not have a talk shop every day, every month, and not make progress nonetheless, right? So we will do that. No, everyone here I'm familiar with everyone here. I think I have worked or continue to work with a number of them. So it's quite easy. We do have the PIA, which has established a robust legal and institutional framework, but beyond that, there are questions around compliance, around certainty, because certainty is critical in investment decision making. That's why we hear FID. FID does take time. You need to check. You want to be sure that your licenses, permits, tariffs, and regulatory policies are administered in a predictable manner over the lifespan of your investment. And Dr. Tolorunse had given us a very interesting presentation. I'll start asking him questions. He'll be my first, the first person I'll be asking a question. From the authority's perspective, it's a two-in-one question, right? From the authority's perspective, what does regulatory certainty mean in practical terms under the post-PIA framework? And how is the authority working to ensure that licenses, permits, approvals, etc. are administered in a predictable and consistent manner? One. Two, in a situation where the authority does make a mistake in granting a permit, maybe to B instead of to A, how do you deal with that? I've looked at section 120, but how do you deal with that in practical terms, and how long do you expect that sort of situation will take before it's remedied? Thank you.
Thank you very much. Your first question relates to certainty in our regulatory landscape. In my presentation, I talked about regulatory certainty. What are the pillars? That our legal framework should be stable. It should be predictable. It should be interpreted just using its ordinary, we know the canon of interpretation as lawyers. We must be able to interpret it correctly, to make it predictable, so that the investor can come and can just invest and go and sleep. We're trying to move to an era. I have been an advocate of a situation where the industry is even self-regulated. Self-regulated in the sense that we don't have to go out all the time, even checking. We will just believe what you tell us. We will have fair regulations, and we will, because of the fact that there's a mutual trust and a mutual trust between us, we will just believe what you have told us. But we must build that trust. So predictability. Investor must be able to say, oh, if I invest, this is how the law will be applied. It's very, very, very key. So in the authority, we're moving towards that, if we have not even achieved it. We are making sure that our interpretation of the law is consistent, is applied uniformly. And we are even moving towards making our inspection, our monitoring to be risk-based. Risk-based in the sense that you allocate more time to area you feel that there's much risk. Where there's no risk, you will allocate less time for supervision in that area. So if you find out that an operator consistently breach your regulations, consistently not adhering to your regulation, you devote much time to that operator. But the ones that are really even complying on their own, we don't need to waste your resources in that. So it should be risk-based as well. Then your second question, if you remind me, your second question, please.
My second question. When you find out that you've made a mistake, not clerical now, maybe you give a permit or a license to A when it's supposed to be B. One, how do you deal with that? Two, how quickly will you resolve?
Okay, yeah, I will answer it this way. Presently, the situation you are even talking, I don't see it even arising, because presently we have digitized our permitting processes. Most of our permitting, you can apply online, and you just front load your documents, they check, and if they check and it's correct, you process, and you get a permit. Even your permit, you can print it online yourself. So the situation of giving another permit, a permit to a person who didn't apply, or who applied but was given a wrong permit, I don't see it as happening. Even if it happened, and you contact the authority, of course, authority will give it the deserved attention, and it will be corrected. So to me, it's not an issue. Once it is not the fault of the applicant, it arises from the authority. We will do it free of charge. We're not going to charge you again, and we're going to give it utmost attention. Thank you.
Okay, thank you. I might come back to that because you didn't completely answer my question. You give to A instead of B, they both apply for the same thing. You now realize that should have been given to B, not A, is my question. There's a live case, that's why I ask. But we will
Maybe
get there.
You can share the live case.
No, I can't share that here. Okay, before I leave my left side, I would ask Okezi a quick question. From the perspective of an operator involved in gas and energy infrastructure, what are the key regulatory issues that most affect bankability and execution of midstream gas projects? from your own perspective? What are those things that have impacted bankability for you?
Thank you very much, Doctor, for that question. I think the first thing that pops up in my head now is ensuring that you have the proper payment mechanisms in place, like payment security, because it's not just wanting to have a bankable project. Do you have bankable contracts? Most operators, most investors, the very first thing they want to see is, have you signed bankable contracts? If you have a bankable contract, then we can begin to discuss having bankable projects. And of course, in your contracts, certain terms should be locked in. Your payment mechanism should be locked in. Proper payment securities put into that contract. And I'll also raise a real-life scenario that I'm aware of, which has to do with, it's a regulatory issue, which has to do with the new regulations on assignment and transfer of licenses. I'm aware that a colleague called me and told me that his company is interested in divesting some of their equity, getting some investors on board. But they met some kind of stumbling block in the shape of that regulation. The first question the investors were asking is, why do we need, because all we are doing is we are just buying some shares, minor shares. Why do we need the regulators to consent to that? We can understand the regulators needing to consent to a transfer of a license, but why shares? I mean, we're just buying a couple of maybe 20%, 30% shares from a company. And then we were going back and forth because he was obviously seeking my opinion on it. And I was being quite frank with him, and I told him that, yes, I believe that regulators should be focused on certain things. We come to events like this, we talk about regulators creating an enabling environment, not just trying to have oversight on operations there. And if they really want to create an enabling environment, they should be able to allow certain activities happen without really trying to stifle it or having some kind of control over it. If you look at the regulation I mentioned, there's a penalty attached to it, I think about $100,000 if you do not get the necessary consent. On top of that, there's also a quite high processing fee, 5% of the total valuation. And at the end of the day, the investors backed off and said, oh, it's too much scrutiny. You're going to carry out DD on us. You're going to carry out legal, financial DD on us. All we just want to do is just bring some money in and invest, because the friends' company needed to bring in funds for a couple of projects they had. So you have these scenarios where they could easily cause regulatory issues, especially when an operator is trying to bring in funding for his project. But one of the things that my boss has mentioned is that he spoke about self-regulation, which I believe is commendable. But on top of what he said, I probably would just add briefly that not just encouraging operators to be compliant, we need our regulators to also maintain zero tolerance for non-compliance. They've been doing that, and we commend them for that, but at the same time, we need them to do a lot much more. And then finally, I'll probably add that to operators out there listening to me, add that it's good if we engage our regulators as early as possible. So you have a project, you're at the initial stage of trying to understand and structure out your projects. It's always good to have at the back of your minds our regulations, our regulators, we need to engage them. From the onset, we need to begin to talk to them so that they can properly guide us on what we need to do. And these are the little things that investors will look at and ask, have you locked in the regulations? Do you have a good relationship with the regulators? Are you able to guarantee us that you'll be able to get the necessary license permits within the shortest possible time? So those are a couple of issues I can mention.
Thank you, very interesting. You speak about regular communication with the regulator. We then go to Ijeoma. You're already operating. What are those day-to-day regulatory compliance issues you have? Where do you think the industry still needs clearer guidance from the regulator, especially in relation to licensing? approvals, reporting obligations, and regulatory interface.
Thank you, Mr. Moderator. Hello? Hello? Thank you, Mr. Moderator, for that question. Yes, you're correct. We are currently operating in the industry. And just to say that, and to thank the authority, because with the enactment of the regulations, we now have a semblance, of what guidance and regulation for the industry and the space and the sector should look like. But just to say that we have not arrived where the goal point is. Take, for instance, an application for regulatory permits and approvals. Dr. Tolorunse mentioned that it should form part of your project design. Understood and accepted. We include it, but it's one item that is not ticked off in terms of timing. You have every other thing properly dimensioned. You have an idea of when the deliverables for every other item is supposed to be achieved, except for regulatory permits and approval. And it's not that you haven't put your foot forward to make that request or to submit the requested information and documentation. But what happens is the other side goes silent for some reason. Even when you're engaging, you have contact and continuous contact and engagement with the regulator. There is no end sight to when the approvals or the permits, would come. That is one. He had also mentioned digitization, which is also a good factor for the authority. But just to also mention that not all applications and approvals are on that platform. There are still some that the templates for application are not yet clear, what it should be. The criteria is also not yet defined. And it doesn't give you some sort of comfort to, for your investors, for you to be able to articulate what are the needs and what are the things that are left out. And even when you make a manual application, nobody comes back to say, this is a criteria or this is a checklist we expect you to comply with. So these are two key areas that we believe that the authority need to address and address as quickly as possible. Thank you.
Thank you very much. Tolu, you are GC at a major player. What are those regulatory or policy risks that still influence investor confidence, whether they take final investment decision or walk away in Nigeria's midstream and downstream sector, despite the PIA? We do have reforms introduced by the PIA, but are there those big ticket issues that still maybe attract people or scare them away nonetheless?
Thank you. Hello? Okay. Thank you, my very good friend, Ayo, Dr. Ayo. In the industry today, as an investor, one of the major risks I'll be concerned about, or a typical investor will be concerned about, is so we don't overflog this issue, but it's staring us in the face. Regulatory certainty, regulatory predictability, regulatory consistency. Those are very key issues that any investor will consider. We need to bear in mind that as an investor in the downstream and midstream business, investors have options. We have various countries across Africa that have the same kind of resources we have as a country. So what would be the attraction to me as a country? I spend billions of dollars building infrastructure. I must commend the NMDPRA, I must commend the federal government for the giant strides, which the PIA has brought about, right? And we are getting there, but we still have a long way to go in terms of, the PIA has successfully drawn a line between, regulatory overlaps. NMDPRA on one side, NUPRA on one side. As a player in the upstream industry, I know where to go to. Downstream, midstream, I know where to go to. Now, if we drill down to those fine regulatory lines, you realize that even with the PIA came subsidiary legislation. Some of those subsidiary legislations today, I wouldn't say we are fully implemented. You know, it's when an issue comes up that remember that, okay, there must be something here, let's look into this. We're all just focused on the PIA. So we need to go beyond PIA now. The reality is staring us in the face. What are those concerns that I need to address as a regulator? Certainty, predictability, consistency. If there is a policy today, I bring in money based on that policy, invest billions of dollars based on this policy. Would I wake up tomorrow and there is a 360 or even 180 degrees turnaround because a single wink by a regulator can actually sweep an investment off its feet completely? You know, if we look at the downstream industry today, we have a lot of investors that have invested heavily in storage facilities, invested heavily in downstream infrastructure. You know, we also need to ensure that there is healthy competition in the industry as much as possible, just to ensure that, you know, because if I want to put in my money in a country, I'll look at you, okay, how are the previous investors being treated? So we need to, you know, we can't overflow these issues. Those are the core, and I'm glad it featured prominently in the presentation of Dr. Tolorunse, and these issues can't just be overemphasized.
Thank you very much, Tolu. Thank you. Dr. Tolorunse, I've got a question for you very quickly around regulations and implementation, generally speaking. For example, I'm sure many of us are aware of the import duty exemption regime when you do your LPG, LNG, CNG projects, even your EVs. But you have regulations around those, but getting it can be a challenge in reality, particularly around timelines and the likes. So even where the law is clear, delays, changing interpretations, or administrative bottlenecks can affect project timelines and financing. What concrete steps are you taking as the authority to improve transparency, efficiency, and timelines in regulatory decision making? She did allude to that, and I think Tolu too did. I'd like to hear you speak to that issue.
Thank you. I believe this is one of, I'm quite happy about the turnout of events now. This is a forum where we can actually have feedback on our regulations and our practices. And I'm quite happy about it. And essentially, that is the rationale for holding this kind of engagement. We will take it in good faith. We can't say we are perfect. Areas we know we are not, we need improvement, surely we're going to address that. But let me just comment on a few things about timing of granting approval. Yeah, I'm not here to defend the authority, but most times you find out that somebody put in an application, incomplete application. Then you ask for more document, it's not supplying in on time, you know. And this is a person who really wants to take us on because we have, in our regulations and law, we provide timing for when you put in your application, this is the time you expect it to come out. But when you who submitted the application is not submitting correct, complete applications, you know, that time will be affected. I'm not here to defend authority. Of course, there may be lapses of the authority as well, but I've also noticed some lapses on the applicant. We will continue to address that. The only way, what we have done is to put it in our regulation and said, put in your application. If you don't get it at so time, consider it granted. It's there. So if you enforce that provision, now we know it's our fault. We will not question that. Then Ijoma talked about, is the one that talked about timing. Then he said not all our permits are digitized. Yes, we are still on the digitization processes. Not all, I agree, not all of them are digitized. But those that are not digitized, you can apply manually. You know, and we have guidelines in our website. We go to our website, all our guidelines guiding our processes are publicized there. If you go through that guideline, it will definitely help you. Then, talking about assignment of interest, it's true, the assignment of interest has long been there since the time of Petroleum Act, and it is also repeated in PIA. Transfer of shares is we look at transfer of shares. It's not all transfer of shares that will require our consent. But where transfer of shares will lead to change in control, if substantial amount of shares is being bought that will even amount to a takeover or would lead to a change in management somehow, it is then will require consent. It is then will require consent. Then to talk about the fee, initially it was 5%, but we have reduced it to 2.5%. So it's no longer 5% like that. We discovered that and we try to work out situation, because when we try to implement the law, that assignment fee, we discovered that for a heavy transaction cost, by the time you apply 5%, it's very, very high. So we now try to say, okay, what formula can we use so that for heavy transaction, even they will pay a lower rate. You may say it's injustice, but we find out that is just the best thing. So we have to stagger it. And in fact, we stagger it for even 1.5%. For heavy transaction that runs into millions of dollars, we don't pay 1%, 5%. So we cascaded it down to 2.5%. That's what we have done. And the Honorable Minister approved it. So we addressed that concern. My brother, Dr. Oni, I don't know if I have answered your question. If I have not answered, we can still bring it up.
Yeah, relatively well. You stated what the authority is doing to ensure that all of this improve. Okezi, your company is doing a number of projects. And as an investor committing capital to long-term infrastructure such as your gas processing, transportation, distribution, etc., what regulatory assurances would give the greatest comfort before you take final investment decision on some of these projects?
I think the simple answer should be having stability, regulatory stability, legal stability, basically. Understanding that the goalpost set by the regulators in January is the same one I'm going to meet in December, right? When you are more or less trying to run your financials, run your economics on the project, see how viable it is, there are certain components that you need to play with. And one of them is pricing. You have your regulators who say that some prices are regulated for some sectors. And if you remember, we spoke earlier about the power sector, about how it's expected for the regulators to regulate gas to power prices. But then, for the gas producers, are they comfortable with this? So if I'm trying to develop an asset and then my regulators are telling me that at any point in time, we can change the price, it doesn't give me the confidence I need. And obviously, a foreign investor will be very, very skittish about it, will be concerned about it. So for my company as an operator, first thing we're trying to do is ensure that there's regulatory stability. And I would say to a very, very large extent, the PIA has been able to achieve this. It has carried out, I would say, 50% reset of the entire industry. Now you have clear line of sight of licenses and permits if you are in the midstream that you need to secure for you to embark on a project. And then obviously we had the unbundling of DPR to the two commission and authorities that we have now. But what is also important to me is ensuring that when you are trying to decide on if you are going to push forward on a project, the pricing mechanism should be set. You are thinking of getting a cost-reflective pricing framework. Do our regulators in a position to provide that to me as an investor? Can I look at my regulators and know that there is no point in time when I have put my money ahead, and then tomorrow I'm hearing that, oh, there are certain changes. You understand me? So for an investor, once there's that certainty, then you're a bit comfortable. The assurance, as you've asked, is there. So for me, I would say once there's legal stability, there's sanctity of contracts. So certain contracts that have been signed and executed, parties are able to be bound by the obligations of the contract. Then you can then have a bit of assurance. And then finally, I would say the infrastructure gap we have in the country. Can we have regulations that can support development of more infrastructure? I know it's really for the private sector, to develop your own assets, but then can the regulators, can they play a role in encouraging that discussion between private investors and private players in the sector? Thank you.
Thank you. Very valid point. I've always been of the view that it's government's role to provide backbone infrastructure, and the private sector can improve on it. So if the private sector is going to do it, then there has to be substantial level of certainty, clarity as to pricing, and as to ultimately investors take versus government take 10, 20 years down the line. And the issues around the obsolete bargain is also critical, that you don't invest money and you find out that you can't monetize your investment subsequently. Thank you. Now we'll look inwards. Ijeoma, how can legal and regulatory compliance teams within licensed operators move beyond a reactive compliance role and become more strategic partners in building trust with regulators and improving investor confidence?
Okay, thank you, Dr. Ayo. So this is very critical because you can't even move forward if you don't have a good relationship with your regulator. So first of all, I would advise you make regulatory compliance a strategic add-on to your business. It's not an afterthought. At a time when you are still at conception stages of your project, everything about regulatory compliance, all the obligations that you're supposed to meet should form part of that project decision before you proceed. And then secondly, proactively engage the regulator. Thankfully, we have the authority representatives here, and I hope before the end of this meet, they should be able to make their contact details available. It should be easy for us to walk into NMDPRA to say, these are my concerns. Who can I meet? If there is a desk assigned for particular projects for particular sectors of, the downstream and the midstream sector, have a dedicated desk, have people who man those desks, have people who are reachable so that you can always have deeper handshakes, with these authority representatives. It helps in guidance. And then thirdly, within your organization, make your organization a community of regulatory compliance experts or people. Let every department support each other. Legal shouldn't just be at the head and the tail of regulatory compliance. It should cut across board. In my organization, what we do is we assign these obligations to the respective departments where they are domiciled, so that they also have interface with the regulator, while we support in the terms of meeting and engagement, and in terms of interpretation of what the expectations are. And then maybe fourthly, also try and have internal audits within your system, within your organization, where you are now tracking and monitoring these obligations for closure, ahead of time. It's important, once you have sedimented what the expectations of your organizations are, as far as regulatory compliance is concerned, then you can now track them. You could employ technology to even track. It will give you heads up, prompts, ahead of time, before the timelines reach, to avoid breaches and to avoid defaults. So basically, in a nutshell, regulatory compliance is not an afterthought. It's part of what we do. Any business that is shut down because of regulatory breach, every other thing you're talking about, cannot go on. You can't function, essentially. So it's a core part of every business, and it should be taken that seriously. Thank you.
Thank you very much. Technology and artificial intelligence should now be integrated into what we do, generally speaking. Tolu, final question. Looking ahead, the next 5 years, what should be the top regulatory priorities if Nigeria wants to position itself as the preferred destination for petroleum and energy infrastructure investment in Africa? In your own perspective.
Thanks once again, Dr. Ayoni. All right, so a key priority for me would be transparency, and this would not be discussed in isolation. We've spoken about technology, we've spoken about certainty. Transparency here is the fact that I have a process that is put in place for an application or for a license or a permit. I put in all the documents required for that application, and I think one of the panelists had mentioned was Ijoma. You don't get a response. And there is no explanation to why you don't get a response. There's no investor that will be happy putting in money into such an economy. We have a lot going for us as a country. We have abundant hydrocarbon. We have, in fact, I like the fact that the PIA even tries to commercialize and maximize the potentials we have in our gas, as a country. We have all these going for us already. We have, all these things in abundance. What we now need is to drill down and ensure that we're able to attract those, the quality of investments we need, through our processes, the transparency of those processes, the credibility of the process, the predictability to a large extent, to ensure that, if I tick a box, ABC, is the checklist you have to meet as an investor. Once you tick that checklist, we need to minimize, would I call it subjectivity in the process. We need to ensure that as much as possible, investors are, Again, we also need to look at the area of diversification of, the issue of the participation in the market. To a large extent, we need to ensure that we have an industry where, different players have different roles they play, and all these roles add up to complement each other to give us the desired results as a country. I think I'll leave it there for now.
Thank you very much. Our time is up. So regulatory certainty is not just a legal issue anymore. It's a financing issue, a project development issue, an energy security issue, and ultimately an economic growth issue. Thank you all for joining this session. I don't know if you can take questions, but...
Yes, we can take 2 questions.
Okay.
If we have any questions, please signify by raising your hand. Okay, we have a question from the lady in white. Do we have any other questions? If not, we'll just take that question. Please say your name, what you do, your organization, your question. Please keep it very brief, not a comment, but a question. And let us know which of the panelists or the moderator who you're posing that question to. So a microphone is going to her. Please be reminded, right after this panel, we're going to go for our tea break, and then we'll reconvene. We still have 2 more panel sessions, and we have a cocktail this evening. All right, can we have the question? Okay.
Good afternoon, everyone. My name is Maria Madibayo. I'm a lawyer. I work at 10+. My question is directed to Dr. Tolorenshe, and it's around the deem approval point. We hear you when you say that if the NMDPRA does not respond within the required time, there is a deem approval provision that can be activated. But my question is, how do you operationalize this deem approval in terms of next step? And let me give you an example. So for example, I'm trying to transfer my interest in a license, as the case may be. The final point that cements my interest is when NMDPRA register my name as the holder or as the interest holder in your registry, right? If you say I can activate the deem approval provisions, how do I proceed? Do I proceed to act as if I am the holder of that license, notwithstanding the fact that NMDPRA has not replied, and I know in my mind that my name has not been registered in the registry. So how do I operationalize the deemed approval in terms of next step? And even let's look at it from the perspective of issuance of license. The evidence, the license or the certificate that you give to me is the evidence or a prima facie evidence that I am the owner of that license or I am entitled to act on the basis of that certificate. In an instance whereby I'm activating a deemed approval provision, do you expect me to carry on the activities, notwithstanding the fact that I don't have a certificate from NMDPRA certifying that I am the owner of that facility or I'm entitled to operate that facility as the case may be? Thank you.
The deemed approval provisions is a matter of law, right? That's what the law says. And I think if everybody must implement the law. If the law says if you don't have, if a regulator does not get back to you on time with your application, and you know it's not your fault that you have a deemed approval, yes, that's what the law says. You can enforce the law. Yeah, we have a situation where we will be taking it to court on that issue. And it happened in Lagos then. The person was relying on the deemed approval provisions. And mind you, for consent, we don't issue another license. It's just a letter we give to you, to letter of approval that we normally give if all things goes on well. But it's not as if we're going to issue another license to you. But like I said, it's a matter of law, and it's your choice to enforce it. I don't have to enforce it for you. If you don't receive approval from me, I say, and the law says you have a deemed approval. What you have is deemed approval, and you can bank on it to me. So how you operationalize it is left for the applicant. If you chose not to enforce that provisions, and you are still waiting for a letter or license from authority, that is your choice. But the law says you have a deemed approval, and we recognize that. Even in our dealing, we always have it at the back of our mind that, oh, you have 60 days to process an assignment of interest. 60 days. And if you don't process it, the person can go to bank, he can take it to there and say, this is the law. So you enforce the law. Thank you very much.
Does that answer your question? Okay, thank you. Okay, if we can keep the questions very briefly, we'll take the two questions. Your name, what you do, the question, and who is addressed to. We'll take the two questions, and then we close the Q&A.
Thank you. Franklin Ofua from PNG. I'd like to resituate the response by Doctor to that question with specific reference to the Host Communities Development Trust. You know, you have regulations, you have guidelines. Yeah. Hello? It says the authority has 60 days within which to give approval. And if it is not given, it is deemed approved. The question I think I get from there, which has not been fully answered, is, at the end of 60 days, what is my takeout to the Corporate Affairs Commission that is the second arm of the approval? That's the way I want to see that question, sir.
Thank you, Dr. Chinedu Idike, Seplat Energy PLC. My question is this. We're all committed about regulatory certainty. We're here to talk about regulatory predictability, consistency, certainty. If that is the role of all of us, including the regulator, why should we find ourselves in a situation where the deemed approval provision is being implemented or enforced by an applicant. What can we do to prevent such an occurrence? Because it's all about regulatory certainty. If the law on deemed approval is new in Nigeria, it was not originally part of our laws. And the Nigerian government, in its wisdom, inserted it in the PIA to ensure that business is run and investors get their approvals timeously. So if someone is sitting on an application and 60 days will come and go, and there's no approval, no communication, no rejection, I think it does not, augur well for the industry, and is actually an area that we should address in terms of regulatory certainty. Thank you.
Thank you. We won't be taking any more questions. And please, just a reminder that it's actually questions and not suggestions or feedback. We want to keep it Q&A. There will be a time later today where we can have interactive, that's not just limited to this panel, where you can also share your observations and feedback. Over to you, Dr. Tolorunshe.
The question? Still on dim approval?
Yes.
You see, we work by law, right? The law did not say I should give you dim approval. Yeah? The law says you have a dim approval. It's an approval. The law has given you the approval. The law did not say, authority, if you don't process it within 60 days, give the applicant dim approval. So authority will not give you will not say, I'm giving you dim approval. So what I'm saying in essence is that it's left for the party to enforce that provision and say, I have a dim approval. And if authority challenge you in that respect, you have it. That is what the law says. It's the law. So, and I said, you recall I said that in most cases, the timeline are not satisfied. It may not even be at the fault of the authority, from the fault of the applicant. And from my experience, when we are carrying out due diligence on assignment, application for assignment of interest, most time the applicant will not submit complete document. We will be going back and forth. Submit this, we need this, it's not complete. So it's affecting the time. So you find out that most of the time, even for the authority not being able to meet the time, is both the fault of both parties. So that's why that provision has not really been effectively managed. But I'm saying where the applicant has done all what is expected it to do, and yet approval is not given, it has a dim approval. That's what the law says. Thank you.
Thank you very much. Please, let's put our hands together for our amazing panelists and moderator for truly setting the tone with that really powerful conversation. Please, can you rise for a group picture? And then I'll be inviting Dr. Charles Nwachukwu, Coordinator, Midstream and Downstream Alternative Disputes Resolution Center, NMDPRA. He'll be accompanied by the Regulatory Affairs Lead, Atom Energy Law Advisory, technical partners and organizers for this event, to present a gift on behalf of the NMDPRA. So please, can we rise? And paparazzi, please help to coordinate. Please, can we put our hands together for Dr. Charles Nwachukwu and Mr. Fortune Toma, who will be presenting a gift to our amazing panelists and moderator. I know we're a bit tired, we're a bit weak, so the applause isn't really coming, but if you would just oblige me by just applauding what has been an amazing, a fantastic, and thought-provoking conversation, as you can see from the questions that came up. We'll be going for our tea break right after this picture, and then we'll reconvene in another 20 minutes. We'll be back here in 20 minutes. That's 12:46 for our second panel session. And that will be preceded with the presentation looking at unlocking investor confidence, rethinking institutional interfaces, and enabling policies in Nigeria's petroleum sector. And then we'll have the second panel session. And then, of course, we'll have the third one, and we'll break for lunch. We'll come back in the evening for the cocktail, and then day 2 tomorrow. Big smiles, please. Can we just put our hands together for NMDPRA for organizing the General Counsel and Legal Advisors Forum? This is the 3rd edition, and it keeps getting better and better. As we can see, it's still a packed and full hall. People are ready to engage and to network. Please, ushers, can you start to direct people for the tea break? This is a great time to stretch, to get some fresh air, to meet somebody new, to share feedback, take pictures, post online, hashtag NMDPRA, hashtag Beyond Compliance. As I mentioned, we'll be back in another 20 minutes to reconvene for our second panel session, the second of 3 for today. Please do not leave any of your items unattended to, your bags, your laptops, your phones. Please keep them on your person at all times, even as you exit the hall for the tea break. Remember, we have 20 minutes for our tea break, and we will be starting at 12:45. Thank you very much.